Good day, Crime Talk aficionados. We have a great show for you. First, the defense wants independent testing of evidence in the Bryan Kohberger case. What took so long? Closing arguments begin tomorrow at 9 a.m. Eastern Time in the Karen retrial. Make sure you join us here. We're bringing it to gavel coverage. Lori Vallow continues her losing streak. Harvey Weinstein gets a retrial and it ends in a mistrial. This day in legal history, we go way back in time for our quote of the day, and our dumb criminal of the day makes a slow getaway. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Now, before we get to the docket, let me remind you to go to crimetalksearch.com and sign up for that background subscription service today. When you do, you will be able to do a background search on as many people as you desire here in the United States. And that report is going to be prepared while you wait. You're going to be able to find out all types of information about people. Phone numbers, email addresses, social media presence. Are they married, divorced? Do they have a criminal history? Are they on one of those sex offender registries? Yes, things that, well, you want to know about people that they may not tell you. So go to crimetalksearch.com. You're going to be happy that you did. All right, ladies and gentlemen, I may have to claim the title from Frank, our producer, is the hardest working man in show business. Let me just tell you, my last, 24 hours. I had a court appearance about an hour and a half north of Denver yesterday morning, bright and early. So I was left the house, I think, to get there by 7 a.m. Pretty normal day. And I go do that, come back, do a show yesterday, do a couple of things, then fly to Grand Junction in Crime Talk 1, go to the jail, meet with clients there until 9 p.m., and then get some dinner, and then do court at 8 a.m., fly back here, do another court appearance at 1:30, fortunately at a court just down the road, and well, do a bunch of other stuff. And here I am doing a show. So sorry for its tardiness, but that's why we put it up a little bit late today. All right, let's go ahead and open the record for June 12th, 2025. First, the Bryan Kohberger matter. That's right. There is a motion for independent analysis of evidence in the Bryan Kohberger case filed by the defense, and it's referenced in recent court documents, and it appears to request for the defense to conduct its own forensic testing of specific pieces of evidence held by the prosecution. Now, while the exact detail of the motions are sealed and not fully disclosed to the public, the following provides a little bit of explanation based upon available information and context from recent developments in the case. So, a couple of key points about the motion, all right? Filing and sealing of the motion took place about June 9th through June 11th of this year, and Kohberger's defense team filed this motion to seal defendant's motion and order for independent analysis. The motion itself is sealed, meaning its specific contents, including the type of evidence targeted for independent testing, are not publicly available, and this sealing is likely to protect sensitive case details to prevent prejudicial publicity, consistent with Judge Hippler's efforts to manage leaks and maintain trial fairness. Now, a motion for independent analysis typically seeks permission for the defense to have its own forensic experts examine such things as, well, normally DNA, biological samples, or physical items, or to verify the prosecution's findings or challenges to their reliability. This is standard defense strategy, obviously, in high stakes cases to ensure that the integrity of the evidence and explore alternative interpretations. Now, in the Kohberger case, the defense has repeatedly challenged the prosecution's handling of evidence, particularly the DNA evidence, linking Kohberger to the knife sheath found at the crime scene. Now, the motion likely focuses on some sort of forensic evidence critical to the prosecution's case, such as, well, the DNA evidence, for example. Now, the prosecution has emphasized DNA on a K-bar knife sheath as a statistical match to Kohberger, and that was collected from a cheek swab and as well as the initial finding of the trash from his parents' home in Pennsylvania. Now, this could also include blood trace found on items like a pillow or mattress covered in Kohberger's apartment, which tested positive for blood but have not been conclusively linked to the victims. The defense has previously sought to access cell phone data and lab testing results, which could also be subject to independent analysis. Now, the defense has a history of obviously challenging the prosecution's evidence collection as well as testing methods. For example, back in November of 2024, the defense filed a 160 pages of motions seeking to suppress evidence, including DNA, arguing it was gathered illegally through their investigative genetic genealogy without a warrant. Then in February of this year, Judge Hibbler denied motions to suppress DNA evidence, ruling that Kohberger had no reasonable expectation of privacy in DNA left at a crime scene. And then in March, the defense challenged DNA evidence under victim Madison Mogen's fingernails, noting it was a 3-person mixture of an unknown origin and arguing it should be excluded from trial due to its inconclusive nature. Now, the motion for independent testing likely builds on these challenges, seeking to retest evidence to either confirm or dispute the prosecution's forensic conclusions, potentially identifying errors or alternate explanations, for example, contamination or misidentification. And obviously, it's a challenge to the prosecution's case. Independent testing could undermine the prosecution's narrative of questioning the reliability of DNA matches or other forensic evidence. For instance, the defense has argued that the IgG method used to identify Kohberger was unconstitutional and that other male DNA was found at the scene. Now, the defense has proposed an alternate perpetrator theory, suggesting others may have committed the murder. And independent testing could aim to identify DNA or evidence pointing to someone else. A hearing on this matter is set for June 18th, ladies and gentlemen. And guess what? It could be a tactic to get that motion for continuance, right? The motion aligns with the defense's May 21st request to indefinitely postpone the August 11th, 2025 trial, citing prejudicial media leaks. Independent testing could require additional time, supporting the defense's argument for the delay, though the prosecution has opposed this, emphasizing victims' rights to a timely trial. Now, because the motion is sealed, it's unclear which specific piece of evidence the defense seeks to test, but we can do a little bit of speculation that it has to do with forensic evidence, but offers no concrete details in regards to what is going to be done. Now, previous defense motions have demanded access to lab reports, forensic testing, and DNA records, suggesting that the independent analysis could target similar materials. For example, a May 2023 motion sought lab reports from the FBI and Idaho State Police, including forensic evidence from Kohberger's apartment and vehicle. So the motion was filed alongside other documents, obviously sealed, and is likely under review by Judge Hibbler. No public ruling or hearing date specifically tied to this motion has been reported as of today, June 12th. Now, the upcoming June 18th hearing may indirectly address related issues, as it will cover the defense motion to continue the trial and their alternate perpetrator theory, both of which could be influenced by the outcome of any independent testing. Next on the docket, Karen Reed. There was a charging conference today. That's where they go over jury instructions, ladies and gentlemen. And let's just say now, when you're at the charging conference, it's, to equate it to a sports analogy, it's the bottom of the ninth, bases are loaded, and everyone is bringing up their best hitter against their best pitcher. That's what's going to take place. So closing arguments are tomorrow at 9 a.m. Eastern time. So that's 7 a.m. So that's why Frank gets the hardest working man in show business. He will have us covered with gavel to gavel coverage. And then we will have the verdict watch as well, ladies and gentlemen. I think it'll be a 1 to 2 day jury, maybe one day Friday, over the weekend, come back Monday, make their decision because jurors want to get back to work. All right, so let's talk about the charging conference today. So obviously Karen Reed is charged with second-degree murder, manslaughter while operating a vehicle under the influence, and leaving the scene of a personal injury and or death in connection with the death of her boyfriend, Boston police officer John O'Keefe, back on January 29th of 2022. Prosecutors have alleged that Reed struck O'Keefe with her SUV and left him to die in the snowstorm outside of a house party at 34 Fairview Road in Canton, Massachusetts. Now, the defense has argued that Reed is the victim of a law enforcement conspiracy, claiming that O'Keefe was beaten by other officers at the party. Well, at least that's what they argued in the first trial, and they said they were going to do it in the second trial. But that didn't turn out. All right. Anyway, in the retrial, the defense rested its case on June 11th, and the prosecution declined to call any rebuttal witnesses. And the judge presiding over the case, Judge Cannoni, presided over the jury charging conference to finalize jury instructions today. So what was the big thing? Absence of the third-party culprit and other proposed defense theories. So in their opening statements and pretrial motions, Reed's defense team indicated they would pursue a third-party culprit defense, alleging that individuals such as Bryan Albert, Brian Higgins, or Colin Albert were responsible for O'Keefe's deaths. They suggested that O'Keefe was attacked inside the Albert residence, possibly bitten by the dog, Chloe, and then left to die outside. However, during the trial, the defense failed to meet their evidentiary threshold to substantiate this theory, leading the judge to prohibit arguing that specific individuals, for example, Higgins or Albert, committed the crime or had motive. The defense also proposed a conspiracy theory involving a law enforcement cover-up, but they shifted focus to arguing an inadequate police investigation rather than proving a specific third-party culprit. Now, the absence of evidence supporting a dog attack or a physical altercation inside the home further undermines these initial claims, as noted in the prosecution's assertion that there's been absolutely no evidence of a dog in this case. Now, that's what the defense said they were going to show you in opening. They also said they was going to say there was no accident. And that's what it comes down to. That's why I think it's going to be a relatively quick verdict, because you either think, A, she hit him, and you can rely upon the physical evidence, the data in the car, her own admissions, or you believe that there was never an accident at all, if you believe her experts. So it should be quick, right? Anyway, the jury charging conference was scheduled, obviously, for the day, with the jurors off for the day. And like I said, it was kind of a housekeeping day to finalize jury instructions. They also make sure all the exhibits are in order. It's routine, but usually this is rather quick in most trials. You don't get a whole day to do this. Anyway, like I said, the defense had rested its case the previous day, and the prosecution's decision not to call rebuttal witnesses was a little unexpected. I thought they were going to call people, but hey, that's their case. I think the jury gets it. Anyway, the defense attorney, David Yannetti, renewed his motion for a required finding of not guilty, arguing that the prosecution's case was weakened by defense witnesses who testified that O'Keefe was not struck by Reed's SUV. Yannetti asserted, quote, "If there's no collision, there's no case," end quote. The judge denied that motion promptly, stating that the Commonwealth has met its burden. The judge ruled that the PowerPoint presentation by defense witness Andrew Rentschler was excluded from evidence. Then we moved on. The defense withdrew 2 jury instruction requests. The judge addressed the presumption of innocence, promising to provide clear language for each charge. At the defense request, an instruction was planned regarding her right not to testify. The judge compared last year's instructions to the current requests and decided to go with what they had. Anyway, the third-party culprit and the Bowden defense arguments. The prosecution, represented by the District Attorney Lally, requested that the defense be prohibited from arguing a third-party culprit or the Bowden instruction. The Bowden defense focuses on the inadequacy of the police investigation. Yannetti argued that the police failed to secure the crime scene, contaminated the chain of custody, and showed bias by not pursuing other suspects. The judge permitted the Bowden defense argument and instruction, but ruled that the defense could not argue that Brian Higgins or Brian Albert committed the crime or had any motive, as the evidentiary threshold has not been met. The defense was allowed to argue that the police were aware information about Higgins, but failed to investigate him adequately. The judge ruled on several further instructions, including those for dangerous weapons, a vehicle, and emotional impact photos. She planned to give an implicit bias instruction as directed by the Massachusetts Supreme Court. And for the Aruba incident between Reed and O'Keefe, a prior bad act instruction was proposed with some defense pushback. Instructions regarding Reed's compromised medical state and a missing recording from her parents' house were to be reviewed further, with a decision by early tomorrow morning. The second-degree murder instruction discussion involved the judge modifications to the model homicide instruction to second-degree murder. Lally and Yannetti presented a brief argument. The judge leaned toward using the model instruction, but agreed to review whether certain parts should be omitted. Yannetti submitted redacted text messages from Dr. Daniel Wolf's PowerPoint for prosecution review. The judge urged both parties to resolve any disputes by first thing tomorrow morning to avoid any delays. Yannetti proposed a modified verdict slip for the manslaughter charge, aiming to simplify it compared to the previous trial version, which he found confusing. Lally, the prosecutor, argued that last year's slip was sufficient, and the judge indicated that she was unlikely to adopt a new instruction, but would review it further. The consciousness of guilt instruction. The judge noted that the consciousness of guilt could be inferred from Reed's post-trial television interviews. She offered to include this instruction, which contains language beneficial to the defendant, but the defense declined on that particular language. The curative instruction for the prosecutor's mistake. Defense attorney Alessi requested a curative instruction addressing a prosecution mistake during testimony about holes in O'Keefe's sweatshirt. Brennan had implied that the holes were related to the collision, but later acknowledged that they were made by a forensic scientist. Alessi argued the incident was intentional and confused the jury, potentially undermining defense witnesses Dr. Wolf's credibility. Lally countered that the mistake was immediately corrected and no jury confusion occurred. He noted the defense rejected a stipulation at that time, and the judge, observing no objection was raised during the testimony, and she would consider the request. That's why, ladies and gentlemen, I know people are like, oh, the defense is always objecting. If you don't object, it's not preserved for appellate purposes. And then you're probably not entitled to instructions either. As it relates to curative instructions, Mr. Lally reiterated that highlighting the sweatshirt mistake in the jury instructions would be improper, as it would address during testimony. He emphasized that the defense's rejection of the stipulation mitigated the need for further instruction. Anyway, the judge emphasized her goal for the jurors were to begin deliberating tomorrow, and after closing arguments, she instructed the court officers to contact jurors to arrive at 8:45 a.m. and stay till at least 5 p.m. Why? Because she wants to ensure that they start their deliberations promptly. She aimed at closing arguments to begin at 9, followed by a 30-minute lunch break to avoid sending jurors home for the weekend after the reading of the jury instructions. Anyway, Yannetti raised logistical concerns about his office being 10 minutes from the courthouse, exceeding the 5-minute proximity rule that the attorneys need to be at within their deliberations. The judge indicated she can accommodate that given the security considerations. So there you go, ladies and gentlemen. It's the big day, bottom of the ninth. I mean, let's face it. Karen Reed's team made a lot of assertions throughout this that somebody else did it, that she's totally innocent, there was no accident. We'll have to see if the juries believe it. Now, I don't know if they're going to get second-degree murder, but the defense, let's be clear, the defense wanted a lesser-included offense as it related to a manslaughter charge as well. The defense always asks for lesser-included offenses when you don't want to be convicted of a more serious offense. Just thinking about it. It came from the defense. They're worried about it. That particular charge only carries 5 years. All right. Next on the docket, Lori Vallow. She continues her losing streak. After deliberating for less than an hour on Thursday, a 12-person jury found Lori Vallow guilty of conspiring to murder Brandon Boudreaux. He is the first direct victim in 3 trials that she's faced for conspiracy to commit murder, who survived and could, testify about the experience. Testimony in Vallow's 3rd trial, where she is representing herself yet again, was completed on Wednesday. Jurors returned for deliberation on Thursday. In her closing argument, Vallow said that there was no evidence of a conspiracy, but the prosecutor said that the only explanation that makes sense is that shots were fired at Boudreaux's car outside of his home by someone in the back of a Jeep. The prosecutors noted that Vallow helped her brother, Alex Cox, take the back seat and the back wheel off the Jeep. She had been seen on video putting those items in a storage unit, and Mr. Cox was not seen in the video at that storage unit. Prosecutors say he left his phone with Vallow in Idaho as an alibi while he drove to Arizona in the Jeep and tried to kill Boudreaux. This is Vallow's 3rd criminal trial. She was convicted of murdering 2 of her children, 16-year-old Tylee Ryan and 7-year-old Joshua J.J. Vallow, in Idaho 2 years ago, along with conspiring to murder them and her new husband's then wife, Tammy Daybell. Earlier this year, she was convicted of conspiring to murder her then-husband, Charles Vallow, in Arizona. This week, trial included some outbursts as Vallow repeatedly brought up topics that she was asked to avoid, and the judge threatened that if she continued, he might allow the prosecutors to bring in information about her 4 other murder convictions. In the first trial, in Idaho, she was sentenced to 5 terms of life in prison without the possibility of parole. She chose to wait to be sentenced for conspiring to kill Charles Vallow at the same time as the sentencing in this case. Sentencing is set for July 25th. Vallow asked it to be set as soon as possible, saying that she does not want to delay being sent back to prison in Idaho. Next, who got a new trial? Well, Harvey Weinstein did, right? Remember, we couldn't even say his name back in those days. We had to say famous movie producer. He got a retrial. Why? Because of 404B evidence. Gets him every time. Anyway, he got a mistrial and a not guilty and a guilty. So on June 12th, today, Harvey Weinstein's sex crimes retrial in Manhattan Supreme Court concluded with a mistrial on a rape charge due to a deadlocked jury following some chaotic deliberations marked by alleged threats and dysfunction. The jury, unable to reach a unanimous verdict on whether Weinstein raped actress Jessica Mann in Midtown Hotel in 2013, faced internal conflict, with the foreperson refusing to continue deliberations after claiming a fellow juror threatened him. The judge declared the mistrial, noting that the deliberations were unusually heated, but dismissing claims of severe toxicity after consulting other jurors who described the dysfunction as, well, just exaggerated. Now, the 8-week trial resulted in a split verdict the previous day, with Weinstein convicted of 1 count of first-degree sexual misconduct for assaulting Miriam Haley in 2006. He faces up to 25 years in prison for that charge, but acquitted of a similar charge involving Kaja Sokala. Prosecutors led by the Manhattan District Attorney Alvin Bragg vowed to retry the charge for the 3rd time, emphasizing accountability for survivors like Mann, who affirmed her readiness to testify again. Weinstein's attorney sought dismissal of the charge and plans to appeal the conviction, citing the juror misconduct. Now, Weinstein was previously sentenced to 16 years in California in 2013 and faces a retrial after his 2020 New York conviction was overturned. And obviously, that's just what took place. A hearing to reschedule the next trial is set for July 2. Next on the docket, this day in legal history, June 12th, 1776, Virginia adopted the Declaration of Rights, a precursor to the Bill of Rights, establishing legal protections like due process and freedom from cruel punishment, shaping American legal principles. On June 12, 1931, notorious gangster Al Capone was indicted by a federal grand jury on over 5,000 counts, primarily for prohibition violations, perjury, and tax evasion, leading to his 11-year sentence ultimately. On June 12, 1963, civil rights leader Megan Evers was assassinated in Jackson, Mississippi, shot in his driveway by white supremacist Byron D. La Beckwith. And on June 12, 1964, South African anti-apartheid activist led by Nelson Mandela was sentenced to life in prison. Obviously, he got out. And then on June 12, 1967, Loving v. Virginia was decided by the United States Supreme Court, struck down all state bans on interracial marriages, ruling that they violated the 14th Amendment. And on this date, in 1978, David Berkowitz, a.k.a. the son of Sam, was sentenced to 25 years to life in prison for 6 murders in New York City. And on June 12th, 2016, a mass shooting at the Pulse nightclub in Orlando, Florida, killed 49 people, targeting the LGBTQ plus community, and it sparked debates on gun control, terrorism, and hate crimes. Our legal quote today goes old school. Justice is the constant and perpetual will to allot to every man his due, as cited by Justin Steen's Digest circa 530, ladies and gentlemen, 530. That's 1,500 years ago from today. That was cited by Domitus Ulipan, a Roman jurist. There you go. 530 CE, common area versus BC, crazy stuff. 1,500 years. Just think about that. 1,495 years ago from today's date. And finally, our dumb criminal of the day. A slow speed excavator chase in South Carolina, my adopted home state of South Carolina. I could see this happening there. In an incident that could only be described as bizarrely sluggish, North Charleston police in South Carolina engaged in a peculiar pursuit early Sunday morning, chasing a stolen tractor excavator down U.S. Highway 78 at a leisurely 3 miles per hour, roughly the pace of an average adult stroll. Now, the hour-long escapade, which unfolded at 3:30 a.m., culminated in the apprehension of a 53-year-old suspect now facing charges. The saga began when officers initially responding to an unrelated call spotted the cumbersome construction vehicle equipped with treads and a shovel lumbering across the highway shortly after a burglary report came in from a nearby business that had sustained significant damage. Connecting the dots, police identified the excavator slowly trundling away from the scene as the prime suspect. What follows was a comically slow chase involving multiple patrol cars, their blue lights flashing, and sirens blaring. The excavator's glacial pace forced officers to periodically halt their vehicles to avoid overtaking it. Despite loudspeaker commands to stop, the driver persisted, leading the police on a 72-minute crawl that tested the patience of all involved. The pursuit finally concluded when the excavator veered onto the Charleston County Fairgrounds property, where it promptly became stuck. Seizing the opportunity, the drivers attempted to flee, but was swiftly tracked by a police drone. A K-9 unit quickly apprehended the suspect, bringing this bizarre episode to a close. Now, the 53-year-old driver now faces charges of failure to stop for a blue light and 2 counts of malicious injury to real property. He remains in Charleston County Jail on a $22,000 bond. The incident has left authorities and onlookers alike bemused by the audacity and the sheer slowness of the attempted escape. Anyway, the tale of some misguided ambition, this slow motorist heist serves as a reminder that not all criminals get away are created equal. While the suspect's choice of a tractor excavator may have offered brute force, its lack of speed ensured his capture was the only matter of time. For today's dumb criminal of the day, this ill-fated joyride will likely be remembered as a lesson in choosing one's escape vehicle more wisely. All right, ladies and gentlemen, that's all we have for today. Thanks for watching. We'll see you next time. And remember, the Constitution matters.